Hello, hello. I am thrilled. We have a new filing on the docket. Let's get the docket like his hot hat on. Last night I saw this. It was actually filed on the 26th. Cardi B's attorneys have responded to attorney Ron Rosenstein's opposition to the order to show cause. We've done 3 streams now on this continuing saga in the Emani Ellis versus Cardi B case, all post verdict. And it started with Emani Ellis's motion for a new trial. Then we have all these filings back and forth where Cardi B's attorneys are seeking sanctions against Ron, and Ron is trying to fight, in my opinion, desperately by any means, any argument, whether valid on its face or not, to try to beg the court not to issue sanctions against him. So we're going to hear it in the words of Cardi B's attorneys. I think this is entirely written by Peter Anderson, but let's check. All right, so it's all their signatures here. It's Peter's signature, but the whole firm here. So Peter, Eric, and Daniel. We've also got Lisa Moore down here. And we're going to see what they say. Also want to give a big shout out. This is our second stream of the day. We just watched some wild trial testimony in the Zachary Adams case. But we're here again thanks to our sponsors, J Money, Take It to Trial, Slim Life NJ, Derek Cresson, and Amy E. So thank you so much for helping keeping this going. I really love to do it. That's why we're getting a double feature. And let's get into it, you guys. Whew. So this is the defendant's reply to Ron A. Rosensteinfaza Esquire's objections and response to order to show cause re his trial misconduct. So let's see. They've got this nice little table of contents and then the summary of the reply here. So this is going to give us, if you haven't caught the previous 3 streams or been keeping up with the post-verdict motions, this is going to give us a summary of why we have to be here, why we're here today. In his Ron's November 17th, 2025 objections and response to the court's October 20th order to show cause. And court's order. Court is ordering. Court has already made the order. The objections and response are going to the court's order. But remember, when we read that, the objection and response was mostly written as if it was addressing the other party, Cardi B. Mr. Rosensteinfaza avoids the substance of the order to show cause by manufacturing service and jurisdictional disputes, attacking the adequacy of the Anderson Declaration and the court's order to show cause, and minimizing his conduct as harmless, quote, mistakes. Mr. Rosensteinfaza claims, and feel free to put some fire emojis in the chat anytime there's some spicy legal writing, because we love that. Mr. Rosensteinfaza claims he was never served with the OSC, even though the court has already deemed service effectuated. That's our most recent stream. We read him arguing about how the service, it wasn't properly served upon him. And you can watch me in real time while we were recording that stream going, but didn't the court deem him served? So here we go. Yes, I wasn't crazy. I wasn't losing my mind. And he now waives the claimed issue by filing his response to the OSC. Now, what this means here is if you respond to something, the logic that follows is that you're aware that the thing you're responding to exists. You're acknowledging the existence of the thing that you are reacting to. Otherwise, what are you responding to? He also argues that the court was required to summarily find him in contempt at trial and at the time of his misconduct, a claim that is contrary to California law. And we read through that. We read through the bench notes for this. So that was really interesting. He insists the OSC application must reproduce verbatim the violated orders and that the Anderson Declaration must recite the, quote, elements of contempt, requirements the law simply does not impose. And he attempts to excuse his conduct by invoking lack of prejudice, stress, and financial hardship, none of which explains or excuses his repeated and willful violations of the court's directions. Mr. Rosensteinfaza's violations are established by his own admissions and the trial transcript. For these reasons, the court should find Mr. Rosensteinfaza in contempt and impose sanctions. And really, this whole back and forth, if I was a judge and I'm thinking like, whatever, the court's over, like, do the parties just want to put this behind them? Seems like maybe at some point Cardi B wanted to just move on. She did a statement outside the courthouse saying, I'm not going to come after you, Emani, but next time, whoever else wants to try me, just know I'm going to start suing. Seems like you could read that as Cardi B being fine moving on until Emani Ellis files his motion for a new trial. And again, there was already, court had wanted Janfaza to show cause for some of his trial behavior. Continuing with these filings and begging and crying and the stuff that Ron Janfaza has been doing, if I was Cardi B's side, and honestly, if I was the judge, now I'm going to feel like I need to consider sanctions. Whereas maybe I would have just said, is this really serious enough? I'm just going to find we're not going to hear these motions and we're done. If I was Cardi B and her attorneys, I'd be fired up. I'd be like, heck yeah, let's respond to this. What Janfaza is doing is like poking the bear. Poking the bear. So let's get into some arguments here. The court should find Mr. Janfaza in contempt. So A, Mr. Janfaza's service and jurisdictional challenges fail as a matter of law. Mr. Janfaza argues that the court lacks jurisdiction to find him in contempt because 1, defendant provided paper copies of the application for issuance of order to show cause the day following filing and email service. 2, the court's OSC did not adjust the elements of contempt. And 3, he was not personally served. And the court could only have addressed his in-court misconduct summarily as direct contempt, meaning they should have done it right away. No hearing, no further delays, just make that decision here and now. Each argument fails. So they're going to address it one by one. So the first argument of the defendant's application not being timely filed, they're saying it was timely filed and properly served by email as Janfaza requested. At the conclusion of the trial on September 2nd, 2025, the court instructed defendant to file her application for the order to show cause within 30 days, namely by October 2nd, 2025. And defendant timely filed the application on October 2nd, 2025. Declaration of Daniel, we looked at that. He might have filed a new declaration repeating it, but we saw a declaration from him last stream. A copy of the defendant's application was also served that day on Mr. Janfaza by email. As underlined, this is emphasized, as Mr. Janfaza had previously demanded service by email. Importantly, and actually we have a footnote, his demand for service by email presumably was because his office address registered with the state bar and on his filings, in this case is a fiction. They say to see defendant's ex parte application for order service. We read the application from Cardi B's attorneys asking, hey, court, we've made all of these valid and good faith efforts to serve Ron. We're failing for all of these reasons. When we knock on the address, a magician's answering the door, and a janitor's telling us that Ron's not even allowed to be on this property after a dispute that happened between them. And then what we thought was his family member's house, they're saying he's not there, and then the lights are shutting off, like all these different things. We tried to get him at court, but it was all just virtual appearances. And so the court goes, okay, I deem him served. So that's what they're referencing here, explaining the different service attempts at these different addresses. And their attempts revealed that, per property management, Mr. Janfaza has not been a tenant there in over 15 years when he was kicked off the property. This is what it sounds like. I should have kept the Waluigi emoji in the channel emojis. We're missing that one today, aren't we? So back up here, fun little footnote there. Importantly, Mr. Janfaza does not dispute any of the foregoing. Instead, he claims that defendant's counsel committed a fraud on the court, that's in quotes, by also mailing him a copy of defendant's application in an envelope bearing an October 3rd, 2025 postmark. That, of course, does not change that it was served by email pursuant to his previous written demand. Further, the proof of service states the copy of the application was placed for deposit in accordance with office practice. They cite the declaration here and California Civil Code of Procedural Code 1013A3. That the envelope might have been stamped the next day is immaterial since Mr. Rosengenfaza does not dispute the application was timely filed, as well as timely served by email on October 2nd, 2025. And when we read the procedure, it was coming from, the way it was worded is that the application has to be timely filed. The requirement wasn't for the service to be the same time. But once you file an application, then there's a clock that starts that you do have to properly serve. And it doesn't matter because the court has deemed Genfaza served. This is all his, what was his response? It was like November, I think his responses were like November 5th or something. November 17th. So on November 17th was the last time we got together. Maybe the 18th, whenever I saw it on the docket. But he waited all of this time to take issue with something, this application that was filed on October 2nd, even though he's responded in between. like that just doesn't make sense. That just seems like trying to find any reason to get out of facing sanctions. So there we go. To end this argument out, they say Mr. Rosengenfaza's accusation of a fraud on the court is false, insulting, and just another example of his unprofessional conduct. Hey, Mary, good to see you. Good to see Smart Towel in the building saying Ron being Ron. Good times, good times. Jeevy says, but he asked multiple witnesses during the trial if they knew his office was across the street from the medical building. Like, was he trying to like bolster ahead of time? Matt brought us all popcorn for the Ron saga. Always good to have some popcorn. Good to see you. Hey, Jody. Good morning, Jody. We've got the second argument here. So the court's order to show cause need not address the elements of contempt. So Mr. Rosengenfaza argues that the order to show cause must be denied because it did not address the elements of contempt. So this issue, when Ron was raising it, it was taking issue with the court and the court's order being insufficient. So they cite the response, but even Kohler, so Kohler v. Superior Court, California appeals case from 2010, confirms that it is the order and judgment of contempt, not the order to show cause, that must include the elements of contempt. So the actual finding, not just the notice. Next argument, the order to show cause was properly served. Mr. Rosengenfaza argues that this court, quote, lacks jurisdiction to proceed because he was not personally served with the order to show cause. But his challenges to defendants showing that he evaded service and that his claimed physical office is a fiction all come too late. Yeah, it was like a month and a half later. Mr. Rosengenfaza had the opportunity to appear at the November 6th, 2025 hearing. What happened at that hearing, guys? What happened at that hearing? Because we looked at the minute order. Did Ron show up to that hearing? Did Ron communicate with the court why he wouldn't be able to show up to that hearing? No and no. So he had the opportunity to appear at this ex parte application hearing for alternate service, and he chose not to file an opposition and not even appear. The court has already, and they cite the minute order, the court has already incorrectly determined that defendant's service efforts were sufficient and deemed service of the order to show cause on Mr. Rosengenfaza effectuated. Moreover, Mr. Rosengenfaza's belated assertions of hearsay, to which he failed to object, are wrong. Defendant's exhibits to the ex parte application for order deeming service effectuated consist of 1, machine-generated labels and delivery data, and 2, business records kept in the ordinary course of FedEx's and the process server's operations. So they included, and like, what a pointless use of billable hours. Like, I know Cardi B has money, but this is why sanctions are important. When you do something stupid to waste the court and or the other party's time, part of what sanctions are supposed to accomplish is, if I have to pay my attorneys to respond to your nonsense, I have to pay them their hourly rate to do whatever they need to do to get their like 15 FedEx receipts and all of this different stuff together, put it in a filing, write an affidavit about it, whatever they got to do, and then file it with the court. Part of those sanctions against you need to include a recuperation. I'm going to ask for a recuperation of my attorney's fees. Because why should I have to pay? Why should I have to bear the burden of responding to the stuff that you shouldn't be doing in the first place? So both fall squarely within recognized exceptions to the hearsay rule because they're records. So further, Mr. Rosengenfaza denies engaging in evasive practices, but there is clear evidence to the contrary. For example, he submitted a false office address with his filings in this court and to the state bar. He avoided repeated service attempts at every conceivable office and home address for him, and he refused to respond to emails regarding service of the OSC. The court properly deemed service of the OSC effectuated on these grounds. In any event, these arguments are moot because the court has already deemed the OSC served. And just remember, I'm telling you, if you want to see me go crazy, watch me try to read through Ron's arguments. Because I felt like I was going crazy, seeing his words on paper. So next, Mr. Rosengenfaza's arguments that he cannot be held in indirect contempt misstates applicable case law and the Code of Civil Procedure. Mr. Rosengenfaza repeatedly argues that, quote, the court does not have the authority or jurisdiction to find him in indirect contempt, while acknowledging that his misconduct during the trial occurred in the immediate view of the court. His argument is that to find him in direct contempt, the court was required to summarily deem him in contempt during the trial. That, of course, was an option. It was something that the court may do. We looked at the full bench notes on this issue. It's just one option, but it's not the only option. And they're quoting here the California Code of Civil Procedure 1211A, that when a contempt is committed in the immediate view and presence of the court or of the judge at chambers, it may, italicize, emphasize, it may be punished summarily. But the court has discretion instead to direct the filing of an application for an order to show cause, giving him an opportunity to respond in writing. And I think we looked at some transcript bits where Ron was asking in the transcript, hey, Your Honor, I'd like a chance to respond to that. And the court was like, I'm going to give you that chance, but it's going to be at a later time. So there's even a transcript showing that Ron was given permission and informed that his response would be allowed at a later date. So let's see. They also put here Code of Civil Procedure Section 1211A, indirect contempt procedure track may be used to address contempt committed in the court's presence. So you can do this all at once. Just because the court could have proceeded summarily does not mean it had to. And the court's decision to proceed as it did is no basis for Mr. Rosengenfaza to avoid the court's order to show cause. Now, again, this is Cardi B's attorneys. This is their response, right? This could just be seen as argument, but I think they're right on the mark. And together as a chat, we went through this stuff and came to the same conclusions. You know, it was the kind of issue where the chat is like all the way on the same page when we were reading through these things. And if we can figure it out as mostly non-lawyers, Ron, like read the code, read the case law. Because if you just tried a little, maybe you wouldn't be in this hot water. So Mr. Rosengenfaza, next section here, Mr. Rosengenfaza concedes his on-record willful violations of this court's orders. So Mr. Rosengenfaza's response fails to dispute, and in most instances affirmatively admits, that violations detailed in the declaration of Peter Anderson, that's Cardi B's attorney, that the court adopted as the statements of facts in its OSC. Instead, Mr. Rosengenfaza insists there were no clear orders, claims the declaration did not set forth specific facts, and raises other irrelevant contentions. Each of his arguments fails. So 1, Ron violated clear court orders that were known to him. The July 30th, 2025 in limine ruling was a valid written order served on Mr. Rosenjan-Faza and entered in the court's file. Mr. Rosenjan-Faza appeared, argued against defendant's motions, then submitted to the tentative ruling of the court, which unequivocally granted the motion in limine, including the references to gang affiliations would be improper. Let's see. And we pulled this minute order. When we were looking at Ron argue that this wasn't actually a clear court order, I pulled up the minute order and we read it together. So not only was there like the recitation of what happened orally at the court hearing, but we also looked at the minute order, which is on the docket that any attorney and obviously members of the public, because I pulled it, can go and access and reference before they stupidly claim in a motion that there was no such court order. And when I say if we can do it as a chat, I mean that as all love chat. I mean that with love. That's not to, insult any of us. I'm very proud of what we do as a chat to bring information together. The court also specifically directed that Mr. Rosenjan-Faza not argue in closing matters not admitted into evidence, including his knowingly false assertion that defendant testified that the NBA All-Star Weekend photograph was taken on the day of the alleged incident. There was nothing uncertain about any of the court's orders and instructions. Yet, Mr. Rosenjan-Faza proceeded to raise gang affiliation in his examination of defendant and argue matters not in evidence, including by falsely claiming that defendant testified that the NBA All-Star Weekend photograph was taken on the day of the alleged incident. Mr. Rosenjan-Faza cites in re Marcus, so that's something that Janfaza relied on as case law for the proposition that a contempt proceeding requires the OSC application to set forth verbatim, that's in quotes, or physically include the text of the court orders he violated. First, defendant's application did just that. So they cite the Anderson Declaration, which is referenced in the application, and it quotes. In that declaration, they quote, you would assume verbatim, July 30th, 2025 order granting defendant's motion in limine number 1. Also a citation to the same order granting motion in limine number 3, and also a citation citing, let's see, reporter's transcript. So application and the reporter's transcript from September 2nd, 2025. So the day of the verdict. I think this is when they were arguing on the record about mentions at during closing arguments. I think this is transcripts possibly from closing arguments. Or when Ron asked to take judicial notice, wanted the court to take judicial notice that Cardi B testified that the photo was the same date, and the court was like, I don't think that's how she testified. That's what I think these lines are from. Moreover, Marcus says nothing of the sort. It holds only that a contempt finding must rest on a written order or an order entered in the minutes. So the contemptor has clear notice of what the court prohibited. The court's July 30th, 2025 written in limine ruling satisfy this requirement, and the OSC expressly incorporates them. The certified trial transcripts, which reflect the court's rulings and admonitions, and Mr. Ronron's repeated violations, also independently meet Marcus's requirement of a clear written record of the orders at issue. Nothing in Marcus supports Mr. Ronron's attempt to dodge the most recent request that he be held in contempt and sanction. The most recent request. Oh, man. Heck yeah, if we can do it without Erin, right? We lean heavily on Erin in this chat. She's super valuable, always giving us tons of insights. All of the Erins, but this particular compliment is for attorney Erin, adventure Erin. Lawnard Amber says, I'm late. It's a good one. We're talking about Ron. Good to see you, Lawnard Amber. Curno Audit says Ron is riddled with ridiculousness. I love the alliteration. Love it. Becky says Ron's going to lose his bar card. Couldn't happen to a nicer guy. And you would think, why would you... I really think he's the reason he's even in this hot water. If he just let it rock and let it go to a hearing, the court could have made some findings, maybe made like minor sanctions. But I think this is just stoking the flames. Just stoking the flames. Heck yeah, and great reminder here from YP if you guys want to hit that like button. Not like Ron hit the guy with the glasses or whatever happened in another case that you guys keep telling me about, which just sounds crazy. The glasses mistrial in the hallway. Oh, man. We've got next here. The Anderson Declaration clearly states specific facts establishing contempt. So Mr. Ron also makes the equally meritless argument that the court lacks jurisdiction because the Anderson Declaration lacks the required specificity and does not articulate the essential factual elements of contempt. But the case law, look at the parentheses. Oh, they say the case law, parentheses, including the case law Ron cites, requires merely that the documents initiating a contempt proceeding state the facts constituting the offense. They cite here, let's see, and this goes back to 1962. Documents initiating a contempt proceeding must only state the facts constituting the offense and cannot merely assert that the court order was violated. And then we have Schwartz v. Superior Court from 1896. Holy moly. Same, annulling a contempt judgment based on violations of a stayed mandatory injunction. And a footnote. So, Ex parte Feldhoven, on which Mr. Rosengenfaza also relies, is inapposite, granting habeas relief because the alleged contemner was never served with the underlying orders that form the basis for contempt. So, it only works if this was the situation. But the contemner was put on notice and knew what orders were forming the basis for the contempt. So this Feldhoven thing doesn't apply. We were here. The Anderson Declaration does exactly what these cases require. It identifies each order, each violation, the specific conduct, and the dates and transcript citations supporting each count. So they cite the Anderson Declaration, which identifies the violations of the court's order in limine, excluding Dr. Alex Avila. Also, identifying violations of the court's order to avoid arguing facts not in evidence. And then they go on to say that the court's July 30th written order expressly grants defendant's motion in limine to exclude Dr. Avila. The court's September 2nd admonition was delivered directly to Mr. Rosengenfaza in open court. And we're getting the transcript here. So, and we summoned Aaron. Hey, Adventure Aaron. We summoned Aaron. Aaron, we were just saying that, we were looking through last time we got together to look at Ron's opposition filing, that we were able to pull up some of the bench notes and some of the relevant, sites from the civil code and say like, hey, Ron, we think you've got it wrong, even without your assistance. And if we can do it without you, Ron, who's an actual attorney, should be able to do it. If we as a chat without Aaron, the attorney, can do it. So good to see you, VIP Aaron. Also, Haida, we had where was she? Creatively Gabrielle in the building. Good to see you. Dolly Talk also in the building. Good to see you guys. Yeah, we keep accidentally summoning Aaron without serving her. So there we go. And EJF, see, we're getting the whole Aaron gang together. So here's this transcript, guys, in open court. I think we may have read this already, but let's read it again because it's a good time. So Mr. Anderson, Cardi B's attorney, says, just briefly, a couple questions first. As if you remember, counsel violated a motion in limine order. I would, and now he's talking about arguing things that are not in evidence, which is completely improper. I don't want to object every 5 minutes to his closing argument. I would ask that at least let me say, if the court doesn't want to tell him, that he has to follow the rules. He can't argue to things that aren't in evidence. He can't violate the motions in limine. And then the court cuts him off. The court says, I think it's readily apparent that you can't argue facts that aren't in evidence. And the plaintiff's counsel knows that. I think he knows that he would be violating the rules of professional responsibility by intentionally arguing facts that are outside the evidence that was presented in court. If he wants to present that and you want to object, then that's how we'll proceed. The court. All right. Anything else from plaintiff's counsel? And then Mr. Rosen says, yes, Your Honor. I feel that what counsel has just stated is really below the belt and disrespectful to my side. I would never argue things that are outside of the evidence. And then he does. And then he does. Spoiler alert. He does exactly that. And then the court here finishes this exchange by saying, I think you just said you were going to. So yeah, that was a good little bit of the transcript that I think, I forget where Cardi B's attorneys incorporated it, but maybe in one of the declarations or one of their responses to his responses somewhere. Oh man. The huevos on this guy, says Becky. Let's see. There we go. And GV with the, here we go, the full glasses story. Thank you, GV. So GV says, Ron A. Rosengenfaza, who represents the plaintiff suing Garagos and Garagos, is the case where his assault led to a mistrial. So we can Google those, find that name. Rosengenfaza approached Belalove. I'm just going to say Belalove. Belalove. Called him the B word and asked, do you want to get a piece of me now? Ew. Rosengenfaza proceeded to spin Belalove around, knocking Belalove's glasses to the ground. Segura told the judge. Then Rosengenfaza stomped and kicked the glasses, Segura said. Dang. And then GV has a quote here from Rosengenfaza that says, quote, I don't remember anything physical happening. Well, that you might need a memory check. You might need a memory check because just from reading this, it seems like you've got two witnesses here. Because you've got the person who would be on the receiving end of this, Belalove, and then Segura, whoever Segura is. What? There's another quote from Rosengenfaza. Quote, the only thing I did here is one of the jurors said, Mr. Belalove struck me. This really mirrors the story that Ron says occurred in the hallway outside of the Cardi B trial, where he accuses Peter Anderson of like assault and battery on him and one of his witnesses. And says that the jurors were in the hallway at the time or something like that. This seems like a copy and paste of something that he was accused of previously, that he tried to write and point the fingers and make Peter Anderson look like the bad guy without providing an affidavit from the expert witness that was supposedly battered. Yeah, it's very, very similar. Thank you, GV. That is great, great, great. And a very concise summary. I mean, I think his own quotes speak for themselves. Oh my gosh. Just crazy. Yeah. And Aaron says, somehow I do not think one of the jurors said that. Yeah, me either. Ask them. And then some jurors saw it, but saw it the way that Segura said it went down, I imagine. Judge declared a mistrial and recused herself. Then Ron said, please don't. You're my favorite judge. Oh, so there's just all these messes. And this is the guy that says he has no experience. You have plenty of experience causing a ruckus in court. Back over here, they finish the transcript. Anderson goes on to argue that the OSC expressly incorporates the court's directions. Indeed, Mr. Rosengenfaza's own response to the OSC cites to at least 21 specific examples cited by Peter Anderson, Esquire, in support of the affidavit of the facts constituting the contempt made in the immediate view and the presence of the court. In short, Mr. Rosengenfaza's response confirms that the Anderson Declaration easily meets the requirements for initiating indirect contempt, and nothing in his response provides any basis to hold otherwise. Oh, don't remind us, Matthew. Matt says, I keep remembering how he said his future career is to be a judge. Next, we have Mr. Rosengenfaza's assertion of lack of prejudice and claimed stress and financial hardship are no excuse to his willful violations of court orders. Like, not the time and place to be like, please don't sanction me, judge. I don't have the money. So we've got sub-arguments here. Lack of prejudice is not a defense to contempt. Mr. Rosengenfaza's suggestion that a contempt finding would somehow be a windfall to defendant because his violations cause no prejudice is utter nonsense. And they're citing a response from the declaration of Ron Rosenjan-Faza. And remember, those declarations are like recitations of the argument in the motions and replies. Like the declaration isn't really what a declaration should be, where you attest to like things you have knowledge of. As a preliminary matter, there is no windfall to defendant because any monetary fine imposed for contempt is, quote, payable to the court, not to the opposing party. Further, he ignores his misconduct's impact on the court's conduct of the trial, and that the purpose of contempt proceedings is not to remediate prejudice, but rather to punish for disobedience of a valid order. And they cite here Little versus Superior Court for Los Angeles County. And see also California Civil Procedural Code 1209A5, 1211A, and 1218, defining contempt in terms of willful disobedience of a lawful court order, not whether the contemptor's tactics cause prejudice. Mr. Rosenjan-Faza's defendant won anyway refrain not only fails as a legal defense. They're making this into a song. It underscores that he still does not recognize that the court's orders are mandatory regardless of who prevails at trial. And I'll take this one step further. You're going to argue, defendant won anyway, so what? But you're also motioning for a new trial. You're fighting to let that be the conclusion, the final conclusion, that Cardi B gets to take the win here. And again, while all of these arguments are right, that it's not even relevant, it doesn't make up for you violating a court's order, you're actively fighting with your motion for a new trial to let it stand that the defendant won. So next we get to the stress and financial hardship argument. These things do not negate willful violations of court orders. December 5th, we should have the hearings for the motion for a new trial and the order to show cause. So I really hope there's a stream. What else is going on? I think there's a Courtney Clenny hearing on the 5th. Let me check my calendar real quick. I think there's something else on the 5th. Nope, just those two things that I have. There is a status for Efron v. Myers, but I think that will just be a sealing the deal with Relly for the battery case, the personal injury case. I did see that the request for dismissal was filed, so I don't think they'll even need to tidy any loose ends on that date. But I'll look to see if there's anything interesting. December 8th, Alicia Andrews sentencing. If you missed it, I have a video. It's not a live stream. It's going to be on the video tab of Alicia Andrews' renewed motion for a judgment of acquittal, the JOA, or new trial. And that's being heard at the trial court level. It's Michelle Cisco that will be doing the decision making. It's not at the appeals court. But it gives you like a little outline of the things that they might argue if they take it up on appeal. So, and remember, I've seen a ton of comments over in that video. She's crazy. What does she want? To get convicted of first degree? Just remember, guys, if you're acquitted by a jury, if you're retried, you can't just be retried on the things that a jury has already acquitted you of. So she's really got nothing to lose by filing such a motion. It'd be a trial again, but only on what she was convicted of. So, and out of curiosity, I don't think that that's going to be granted, especially not by Michelle Cisco. I would love to just see the state choose to retry Alicia Andrews and only be able to take her for that second degree manslaughter. Because I would love to see how they'd present and argue that case while they still have to try the other co-defendants for the first degree. They'd have to change their whole theory. So that would just be interesting. Just out of curiosity, I'd love to see it. And then December 9th, we have Fannie Willis v. Kauser et al. So that's going to be, I hope there's an oral argument stream for that. So that's going to be early in the morning, 9 a.m. on the 9th. So we'll get together for that. So that's my calendar, you guys, while we're talking about the next hearing in this matter. But lots of stuff going on December 5th, the 8th, and the 9th. So Mr. Rosenjan-Faza also seeks to minimize his violations by invoking financial hardship, stress, and unfamiliarity with high-profile jury trials. Rosenjan-Faza, they cite his own declaration. Yet he was quite comfortable telling the court he would be spending the trial's intervening dark days and weekend in Las Vegas, Nevada. Referencing Mr. Rosengenfaz's trip to Las Vegas, his arguments are contrived. Further, stress and financial strain do not negate willful violations of court orders. The Supreme Court has held that misconduct cannot be excused or substantially mitigated because of an attorney's needs, no matter how compelling. And the state bar court has repeatedly emphasized that many attorneys experience physical and emotional difficulties without committing misconduct. While these stresses are never easy, we must expect attorneys to cope with them without engaging in misconduct. Mr. Rosengenfaz's attempt to dismiss his misconduct as a rookie mistake fares no better, and they cite his own declaration. First, he's not a quote-unquote rookie. He's been practicing for over 20 years, and his own declaration states that he has proceeded to trial in approximately 10 different cases. Second, willful disobedience does not become unintentional simply because the attorney labels it a mistake. We have a quote here. Disclaimer of an intent to commit contempt is no defense where a contempt clearly appears from the circumstances constituting the act. Oh, I like that. I like that one. That's the City of Vernon v. the Superior Court in and for Los Angeles County from 1952. That's a nice little quote there. What do we got? They also cite other cases here, noting that a claim of good faith under a mistake of law does not excuse disobedience of an order of court otherwise constituting a contempt. I like this one better. Here, the court provided Mr. Rosengenfaza clear orders and directions. Defendant's contemporaneous objections expressly invoked those orders. The court directly admonished him, and yet he willfully chose to repeatedly violate the court's orders, directions, and admonitions. Yeah, I mean, even just this transcript bit, where it's like, all right, anything else? And then the court's like, I think you just stated you were going to. After we have this whole spiel that it should be readily apparent that you can't argue facts that aren't in evidence in your closing. And then shortly after that exchange, he does the very thing. So, there we are. We were here. So this other sub-argument here, sanctions are necessary to deter future misconduct. And this is, again, now you have the party wanting to, like, really spell it out. We really want you to sanction this guy now. Because otherwise, he's going to keep doing this. He's making it apparent within this very case that he's going to continue even when he's told to stop. So, Mr. Rosengenfaza has been severely sanctioned before. Uh-oh. They say, see defendant's response and objections to plaintiff's appeal for issuance of order to show cause. And they cite the Hershey, this is what GV just gave us the context of, the Hershey v. Garagos and Garagos case, which, affirming $22,933 in sanctions imposed on Mr. Rosengenfaza for, quote, making unmeritorious objections, giving evasive responses, violating the court's discovery order, deliberately misrepresenting the date on which responses were served. Oh, that's very similar. That's very similar to this October 2nd and 3rd issue. Deliberately misrepresenting the date on which responses were served. And engaging in dilatory conduct designed to delay and impede discovery and trial preparation. But prior sanctions did not deter him from his willful trial misconduct in this case. A finding of contempt under Code of Civil Procedure Sections 1209A5, 1211A, and 1218, and sanctions under those statutory provisions, California Rules of Professional Conduct 3.4F and 8.4D, all of the code. All of the code says sanctions. Plus, the court's inherent power are both appropriate and necessary to deter him from continuing his misconduct in the future. Mr. Rosengenfaza's response does not challenge that point and thereby concedes it. So, conclusion. Mr. Rosengenfaza's litigation strategy, and I love that. When I pull up a motion before I do a stream, I try to jump to the conclusion to get like a preview before I make a thumbnail. And this is where we got our thumbnail. Mr. Rosengenfaza's litigation strategy includes false statements and blatant disobedience of the court's orders, which the court witnessed during the trial in this action. Defendant respectfully submits that the court should find Mr. Rosengenfaza in contempt impose an appropriate sanction under Code of Civil Procedure Section 177.5 to deter further violations, and file notice with the state bar. Under Business and Professions Code Section 6086.7. So there we go. There we go. Got Peter's signature there on the line. Got the whole gang down here, the whole team. There we go. There we go. Yeah, that's a pretty decent sanctions amount if it's not including like taxing. And I think I saw on the docket Daniel Imacuri had submitted it's like a tax form, and I think what that means is like a line item of anything time used to respond to things that might be sanctionable. So okay, wait. Can I play this live, Aaron, or is YouTube gonna hate me? Let's see. Let me get to the link in the chat. Unless you guys can click it. You guys can click it there in the chat if you want to see what it is. But I bet it's some type of emote, some type of reaction, imitating what Ron might look like. Let's see. I'm sorry, the reason it's taking me so long is on StreamYard, I can't click links. So I got to go over to YouTube to get it.
So I wrote a song.
Oh my God.
Hello there, Your Honor. I want to say I'm sorry for the things I've done, and I try and be stronger in this life I chose, but I want you to know that door I close. In Your Honor, I'm sorry, 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 sorry.
His voice is really nice. His voice is really nice. I'll say that. The cut to the judge's face is great. Shout out to, is this Court TV? Shout out to Court TV's camera people. Oh, this is A&E. Oh my goodness. That is great. That is great, Aaron. I would love to see that, and I hope that there's cameras in there on December 5th to see whatever happens with this. That's it, guys. That's our update on it's the Emani Ellis and Cardi B case, but it's really just the attorneys sparring at this point, right? It's like fight night between the attorneys. A good time all around. Yeah, I mean, the singing is a winning argument. I think so. I think so. The judge just seems lost. Oh man. Yeah, better than Ron's closing. Better than Ron's arguments there. That was awesome. That was awesome, Aaron. I have actually never seen that before. So it seems like this is a well-known court moment. It has not been on my radar before. And not only was it very applicable here, but just in general, I think this is a good one. Thank you, Aaron. Guys, we're going to wrap it up. I don't know if the hearing will be streamed for this, but it is scheduled for the morning of December 5th. This is over in California, so that's going to be Pacific time. So we'll probably have some Courtney Clenny updates before, and I don't know if that's going to be streamed, right? Every time I think something exciting is happening in the Courtney Clenny case that there will finally be cameras back paying attention to, there haven't been. But we'll see because they're going to hear some motions. I don't know. I would hope that somebody gets a camera in for the Courtney Clenny thing. If need be, I'm only 3 hours away from the Miami-Dade courthouse. So put my butt down there and go see what's going on in court. But we could cover that in the morning if there's a stream, and then also see if there's going to be a stream for this hearing. I would think since Cardi B is such a high-profile figure and Court TV, Law and Crime, they could get a ton of viewership for it, that hopefully it's something they go in there for. So that being said, I'm going to go take some time, enjoy my Saturday, probably diving more into the Zachary Adams trial, finding some gems for us to go over for the rest of the week. Might do a stream tomorrow on whatever wacky stuff I find there, or just watching more testimony. So if you guys want to hang out for that, just keep your eyes peeled for a notification. I'll try to schedule the live in advance. Otherwise, we'll be back on Monday with a trial watch starting at like 9:30 Eastern for the Zachary Adams 2017 trial. So you guys all have a good one. Thank you so much for hanging out with me, especially if you spent 2 streams with me. I'm honored. And Danielle, oh, we're leaving, Danielle, but hey, good to see you. You're going to have to be Rewind crew. But it was a good one. It was as short as 11-page motion. You should get through it. You'll be there with Destined to Be on the Rewind crew. Shout out to everyone, guys. And if you're on Replay crew, make sure you leave a comment. Pretend it's your chat. And see you guys at some point somewhere. Bye, guys.